So today, we're diving into a case that wasn't just about one person's life or death. No, this was about the power of the state itself, the power to take a human life. We're talking about Bachan Singh versus the State of Punjab, the incredible legal showdown that literally put the death penalty on trial in India.
You know, the Bachan Singh case boiled down to one of the most fundamental questions a society can ask itself. Does the government, does the state have the right to kill someone? And if it does, where on earth do you draw the line? At what point does a crime become so awful, so heinous, that the only possible answer is death?
And back in 1980, this wasn't just some philosophical coffee shop debate. It was a full-blown constitutional firestorm, and it landed right in the lap of India's Supreme Court. The case of one man, Bachan Singh, suddenly became the battleground for the entire future of capital punishment in the country.
Now, to really get why this case was so explosive, we need to back up a little. You have to see how the ground was already shifting under everyone's feet. See, the court wasn't starting from scratch here. A whole century of legal change had been building up to this very moment.
Think about this. For almost 80 years, the law basically said that if you were convicted of murder, death was the expected punishment. That was the default. But then, just a few years before our case, in 1973, Parliament completely flipped the script. All of a sudden, life imprisonment was the new normal, and the death penalty became the rare exception, something a judge had to give special reasons for. That one change, right there, set the stage for a massive challenge to the whole idea. So, with the legal landscape already changing, the challengers saw their opening. They decided to launch a direct assault on the death penalty's constitutionality, and they aimed their arguments at two of India's most sacred fundamental rights. They came at it from two different angles. First, they used Article 19. Their argument was pretty straightforward. Execution is the ultimate, most unreasonable restriction on all your basic freedoms. I mean, you can't exactly exercise your freedom of speech or assembly if you're, well, dead. The second, and much more direct challenge, was under Article 21, the fundamental right to life itself. So the court's first job was to figure out which of these articles was the right place to even have this debate. While the court pretty quickly shut down the Article 19 argument, they looked back at an older case where Justice Sastry had made a really powerful point. He basically said, look, if you start saying that just being in prison is a restriction on your freedom of speech, then pretty much every criminal law would be unconstitutional. It would be chaos, a reductio ad absurdum. It would make the whole provision look ridiculous. So the court agreed. This fight wasn't about restricting freedoms. It was about the total deprivation of life. We put the whole battle squarely under Article 21. All right, so the battleground is officially Article 21. Now the court had to roll up its sleeves and weigh the timeless, powerful arguments for and against capital punishment. This turned into a huge intellectual showdown, balancing society's oldest instincts for justice against its highest, most modern ideals. First up, the classic deterrence debate. Does the death penalty actually stop other people from committing similar crimes? Those who wanted to keep it, the retentionists, said absolutely. The fear of death is the ultimate deterrent. But the abolitionists fired right back, pointing to studies from all over the world and saying, show us the proof. They argued there's simply no conclusive data showing that the death penalty works any better than life in prison. The numbers just aren't there. Next, they moved on to the moral argument, retribution. Is it about justice, or is it about revenge? The retentionists framed it as societal justice, a way for society as a whole to express its absolute outrage and condemn a terrible crime. But the abolitionists said, let's call it what it is, state-sanctioned vengeance. It's that primitive eye for an eye impulse that, they argued, has no place in a modern civilized nation. And finally, maybe the most chilling argument of them all, the fact that you can't take it back. The abolitionists made a powerful point. Our justice system is run by human beings, and human beings make mistakes. The risk of executing an innocent person is always there. You can release someone from a life sentence if you find out they were innocent. You can't reverse an execution. The retentionists acknowledged this risk, but their answer was, well, that's not a reason to get rid of the punishment. It's a reason to build a better, more foolproof system. So, faced with these incredibly powerful, deeply conflicting arguments, what did the Supreme Court do? They didn't just pick a side. Instead, they forged a historic compromise, a brand new legal doctrine designed to try and balance the scales between the demands of justice and the sanctity of life. And the court's solution was the now famous rarest of rare doctrine. It said, okay,
The death penalty is constitutional. It can exist. But, and this is a huge but, it cannot be the norm. It must be reserved only for the most extreme, the most exceptional, the most heinous cases, where the option of life in prison is, and I'm quoting here, unquestionably foreclosed. So how does this actually work in a courtroom? Well, the court laid out a new two-part system. First, you have the trial, which is only about determining guilt or innocence. Then, if the person is found guilty, you have a completely separate hearing just about the sentence. And in that second hearing, the judge has to weigh what are called aggravating factors, things like the brutality of the crime, against mitigating factors, like the criminal's background, age, or potential for reform. Only after weighing both sides can a death sentence be considered, and even then, only with very clear, written-down special reasons. Now, you might think a huge ruling like this would settle the debate for good, but the Bachan Singh judgment didn't end the argument over the death penalty in India. Not at all. In many ways, it just reshaped it, leaving behind a really complex and enduring legacy that people are still fighting over to this day. So, what's the lasting impact? Let's break it down. Bachan Singh did 4 huge things. 1, it kept the death penalty on the books. It's still legal. 2, it officially made life imprisonment the default punishment. 3, it forced courts to look at the criminal as a person, not just the crime as an act. And 4, most importantly, it created this new super high standard, rarest of rare, which sounds great in theory, but as we're about to see, is incredibly subjective in practice. And if you want a perfect, chilling example of what subjective really means, just look at this real case that happened later. You have 3 men, Jita, Kashwira, and Bachan Singh, all convicted for the exact same crime, playing an equal part. But their appeals ended up in front of different judges at the Supreme Court. Jita Singh's appeal was dismissed, he was executed. Kashmira Singh's appeal was heard by a different bench. His sentence was changed to life in prison. And Bachan Singh? He was also going to be executed, but was saved at the very last minute when the court realized what had happened to the other 2. Same crime, same role, 3 completely different fates.
And this really brings us right back to the question that still hangs over the legacy of Bachan Singh. The entire point of the rarest of rare doctrine was to remove randomness, to eliminate arbitrariness by setting an impossibly high bar. But if clearing that bar just depends on the personal, subjective view of the judges you happen to get, did it really get rid of the randomness, or did it just give it a new name? That's a question India's legal system is still wrestling with today.